Hi, I'm Jacob Appel, and welcome to week 1 of Bioethics the Law. We're going to begin by talking about reproduction in the law. But I want to emphasize that even though the materials this week may be challenging, you will get the hang of them, and they will get easier with time. In order to master the material, I strongly urge you to first read the synopsis available under the course materials each week, which is usually 2 to 3 pages and covers a framework for the material that follows. Then watch the lecture, and then try to dive into some of the case material. There will also be live sessions each week to discuss the case material. So if you don't understand any of the particular cases, we can discuss them in person virtually to figure out what's actually going on. This first week is not just an introduction to reproduction in the law, but also an introduction to the law itself. And as such, the first half of this lecture will discuss the nature of the American legal system. This may be familiar to some of you, but not to others. And then the second half of the talk will talk about the specific issues in reproductive law that are up for discussion this week. I will emphasize that there are going to be 2 different sessions this week, one this coming Monday and one the following Saturday, where we can meet in person online to discuss these issues. The nature of the American legal system may be vaguely familiar to some of you, either from high school history or high school civics classes, in which case this will be a review. For those of you who it's not, or for those of you who have forgotten, the United States is a federal system. That means the federal government, the government in Washington, can only do things that it's authorized to do under the US Constitution, so-called enumerated powers. And things that it's not specifically allowed to do under the Constitution, it can't do, and only the states can do. However, those rules were designed for the 18th century, and the countries have changed a great deal since the writing of the Constitution. So the federal government in Washington has designed several workarounds to enable it more control over states and individuals through the law. How has it done this? 2 examples will give you a sense of the workarounds that have been developed. First, while the federal government can't necessarily legislate in areas like highway speed limits or the age at which alcohol can be consumed, it can tie federal money to following its guidelines in this area. So during the 1970s and 1980s, the government wanted states to lower their driving ages from 65 or 70 miles an hour to 55 miles an hour, and to raise the age at which teenagers could buy alcohol from 18 to 21. So in order to pressure or coerce or persuade the states, depending on your viewpoint, to pass laws that lowered the speed limit and raised the driving age, it tied federal highway money to doing so. So if you wanted to get federal highway dollars, you had to agree to lower your speed limits and raise your drinking ages. The federal government also has used the Commerce Clause of the Constitution to expand its power. The Constitution says the federal government in Washington can regulate interstate commerce. But what exactly is interstate commerce? Well, the courts historically have defined it much more broadly than you might intuitively think. So, for example, Congress passed a law in the 1930s called the Agricultural Adjustment Act that was designed to support the prices of agricultural products by limiting the amount of grain a farmer could grow on his own farm. And in this case, the farmer was growing wheat to feed to his own farm animals. And he went to the Supreme Court in the case of Wickard versus Filburn, and he said, sure, the Supreme Court may be able to regulate interstate commerce, but I'm growing wheat on my own farm for my own animals. How is that interstate commerce? And the Supreme Court said that it was. It said that by growing his own wheat, this farmer was choosing not to buy wheat on the international market, and therefore infinitesimally affecting the international price of wheat. Thus, it was interstate commerce and thus could be regulated by the federal government. I mean, that's pretty far-fetched, but that is the rule. In a similar way, during the 1960s, in the case of Katzenbach versus McClung, the federal government, the courts, were asked whether or not Congress could legislate civil rights laws that restricted the rights of store proprietors and restaurant owners to discriminate against non-white customers. And in this particular case, Ollie's Barbecue was a barbecue shop in Alabama that only served a local clientele. and it only served a white local clientele in-house. It actually offered takeout only to African-American customers, which violated the Civil Rights Acts the federal government had passed. But Ollie's owner went to the Supreme Court and he said, I'm not engaged in interstate commerce. And the court disagreed. The court said the products he bought that he served in his restaurant, for example, the condiments that he purchased, were manufactured in other states. And therefore, his restaurant as a whole was engaged in interstate commerce, and the federal government should regulate it. You should not memorize the particulars of these cases. The larger point, the federal government has created clever workarounds to allow it to regulate large swaths of the American economy. In all fields and areas where the federal government has the authority to act, federal rules trump state rules. In all areas, state rules trump local law. So if there's a federal rule and it's an area where the federal government has the right to act, a state can't pass a law that challenges that federal rule. So, for example, if there were a constitutional right to abortion, under federal law, a state could not pass and enforce a law banning abortion. Look at a number of different types of court cases over the next 10 weeks. And the question you want to ask yourself in each of these cases is what kind of case it is. And there are 4 different questions you're going to ask, and we'll review this with each case. But first, you want to ask what the jurisdiction is. Is it a case under federal law, under state law, or under local law? Second, you want to ask what the source of the law is. Is the law in the Constitution? Is it a statutory law, a law passed by Congress or by a state legislature? Is it administrative law? Administrative law are the regulations that agencies pass to fill in the gaps between state laws. So, for example, in New York State, there's a state law that says that one has to report child abuse as a physician. But whether that applies in professional settings only, or also if you discover it in a social setting, was not entirely clear until the state administrative agencies specified in regulations that it only applied to professional and not social circumstances. And finally, is it a common law case, which means is it an area of the law where there is no statute, no administrative ruling, where judges have to decide based on precedent and previous example. And then it won't play a large role in this course, but you might ask yourself, is this a criminal law case or a civil law case? Meaning, is it something for which one can be sentenced to prison or in theory pay a fine, or is it something where one can only pay a verdict to another party? And finally, if it is a civil case, and we will look at a few civil cases during this course, does it occur under a contract or is it a tort case? What does that mean? In a civil case is when 2 different parties sue each other. When they have an agreement prior to the lawsuit, for example, a written contract, then the case will be about what the contract said and whether it was enforceable. In the absence of a contract between the 2 parties, let's say I hit you with my automobile and we've never met each other before, a personal injury case, for example, cases without a contract known as tort cases. And there, the general rules of reasonable people will apply. And we'll explore each of these questions as these cases come up during the course of the semester. So to review, in looking at a case of controversy, you want to answer the following 4 questions. What is the jurisdiction, federal, state, or local? What is the source of law, constitutional, statutory, regulatory, or common law? Is it a criminal case or is it a civil case? And if it's a civil case, is it a contract case or a tort case? To help you out, I will tell you that this week, all of the cases we are looking at are federal cases dealing with the right to abortion or other rights allegedly or not allegedly protected under the Constitution. And they are generally constitutional cases. They ask, what rights does the Constitution protect? As we go through the course, we will look at other kinds of cases, particularly a lot of state cases that deal with state legislative rules and statutes. But for now, we're talking about federal law and the Constitution. Another way of thinking about it is, where does the source of the law come from? Does it come from the Constitution, in which case it is very difficult to change without a meeting of a convention or a body of the people? Is it statutory law, which generally can be passed or removed by a majority of the legislature? Is it the administrative type law I talked about earlier, where bureaucrats fill in the gaps, like the child abuse example I mentioned? Or is it judges making the law, filling in the gaps where other agencies and legislatures have not taken action? You've noticed the last three slides have repeated the same concepts in different ways, just so they get drilled down for you. And a bit more about civil cases and criminal cases. Civil cases generally have two parties litigating against each other over some kind of conflict. The plaintiff, the person suing, and the defendant, the person being sued. In the United States, very few rights kick in, meaning you don't have a right to a lawyer, the government doesn't pay for your experts in general, and parties have to pay their own way. In contrast, in Great Britain, for example, the losing party generally has to pay the legal cost of the winning party. Often these lawsuits are funded on a contingency basis, meaning a lawyer will tell the client, you don't have to pay me anything up front, and you don't have to pay me anything if you lose. But if you win, I get a third of the profits. And that's generally how malpractice cases, for example, are handled. In a civil case, it is a purely adversarial process. The duties of the plaintiff and the defendant are largely the same, and their lawyers largely the same on behalf of each other. Neither is pursuing truth, although lying is generally not permitted. Both are pursuing their own interests. Cases are very different. Criminal cases are generally fashioned as the people versus a particular individual, or the United States, or the Attorney General, Attorney General Ashcroft, Attorney General Holder versus the defendant. And here, constitutional rights do kick in. You do have a right to an attorney. You do have a right to a trial by jury. You may have a right to have experts paid for you under some circumstances. And here, the duties of the prosecutor and the defense are different. The goal of the defense attorney is to persuade the judge or jury that his client isn't guilty, whether his client is guilty or not. Presumably, the duty of the prosecutor is not to prosecute people he or she doesn't think are guilty. So it's an asymmetric relationship. A bit about contracts and torts. So historically, the principle of law that applied to doctor-patient relationships was a contract relationship. Basically, whatever the doctor and patient had agreed to was what the court decided about. So the question was what the doctor had offered, what terms the patient had accepted. Courts did not get involved in the question, was this a good contract or not? They only cared whether it was a contract. In contrast, today, courts sometimes do look at the question of what a good contract is, and doctors generally can't contract outside the standard of care or acceptable practice, even if the patient agrees. So, for example, if at the Albany Medical Center, they say that for full price, we will perform surgery with a scalpel, but for half price, we'll save some money, we'll do it with a cleaver. Even if the patient fully understands the risks and agrees, when that goes to court, that can still be malpractice. You can't contract out of what reasonable doctors would do. And this actually becomes a controversial issue in cases of complementary and alternative medicine, where you're doing something that you think may help the patient, but it's not the standard practice. Also familiarize yourself with the concept of standing, because it's going to be an important issue in reproductive rights law. Standing is the principle that a party has to have a legal relationship and usually some demonstrated harm in a case in order to sue. So a practical example, let us say I am walking in New York City one day and I see someone I don't know get hit by a bus. And I say, that's a terrible thing. They shake themselves off and they walk away. And I run up to them and I say, you should sue the bus company. They're in the wrong. And they say, I don't want to sue. But I'm still offended by this. I want to help them out. So I sue on their behalf. So in general, you cannot sue on someone's behalf in the United States. Only the party who is injured can sue. And that is called standing. Standing gives you the right to sue. So an example of how standing historically mattered was it was very hard to litigate the question of abortion, because the average pregnancy, as I assume many of you know, takes 9 months. And the average case in federal court takes 2 years. So by the time the mother had given birth to the child, 9 months had gone by, the court case had not been adjudicated, they no longer had standing to sue to claim the right to have an abortion. And the courts actually carved out an exception to abortion cases, where they said, since abortion cases are likely to come up over and over again and always evade review because of the time differences, we'll make the decision based on having had standing when you filed the lawsuit and not standing at the time of the hearing. And that's how abortion cases got to court. But in other areas, standing remains a complex issue. You can't sue the government, for example, but you don't like its foreign policy. because you don't have a particular vested stake in the government's foreign policy. We'll shift to the part of the lecture dealing with reproductive rights, and we're going to begin with the 14th Amendment to the Constitution. The 14th Amendment, which was passed after the Civil War, states in part, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, or deny any person within its jurisdiction of the equal protection of the laws." So while some cases related to reproductive rights have arisen under the Equal Protection Clause and the importance of treating men and women equally, most have arisen under the second clause, the part that says no state shall deny any person of life, liberty, or property without due process of law. Now, this clause has been interpreted to mean two different things. One, it has been interpreted to mean the Constitution can't deprive you of life, liberty, or property without the right procedure. Procedural due process is what that is known as. They have to give you a fair hearing, they have to treat you fairly before the law, and there are whole sets of rules of what it means to be treated fairly with due process. But this section of the Constitution has also, in the 20th century, been interpreted to have a substantive element, what is known as substantive due process, meaning there are certain rights that are so fundamental that even if they give you the right procedure, the government still can't take action and restrain your liberty or property in certain ways. And those are the areas we're going to look at with reproductive rights today. The challenge with the term liberty is it means different things to different people. So liberty could mean economic liberty, it could mean personal liberty, or it could mean both. Some judges have enumerated a long list of individual rights that are covered by the term liberty. Others, and Justice Frankfurter is most famously associated with this approach, say that liberty are things that are fundamental to ordered liberty in a free society. Basically, if you denied certain rights to people, could we still consider ourselves a free people? We shall see in a moment that liberty has been interpreted very differently at different times in the nation's history. The definition of liberty, which is important for reproductive rights cases, actually arose as a constitutional question in an entirely different matter, the case of Lochner versus New York, but this had laid the groundwork for the debates that followed. In this case, New York State had passed a wages and hours law that, among other things, limited the number of hours that bakers could work. It was considered a law designed to help laborers at the expense of management. The question that arose was whether or not liberty under the 14th Amendment included the liberty to contract to work for as many hours as you wanted to as a worker. And Lochner sued the state of New York, saying that the Constitution granted workers exactly that. And the Supreme Court agreed, with a majority saying that yes, the Constitution did protect the substantive right or the substantive due process of workers to contract for as much as they wanted to in terms of wages and hours under the 14th Amendment. And therefore the law, which was a state law, was unconstitutional under the federal Constitution. A minority of the court said that yes, that in principle was right, that the federal government had a right to strike down laws at the state level that violated liberty, but that because this was a health law, it wasn't a traditional regulation of the economy law. It was a separate area where the police power of the state applied and the state did have authority. But Justice Oliver Wendell Holmes, dissenting, said the courts were asking entirely the wrong question. The real question was whether or not this was an issue for the legislature or this was an issue for the courts and the Constitution. And he argued that these sorts of questions were questions to be decided by the legislature and by the people and shouldn't be intervened with by the courts. The question of whether reproductive rights fell under the definition of liberty didn't come to the Supreme Court until 1927. And in that famous case, Buck versus Bell, the question was whether Virginia's law that mandated the sterilization of the children of people whose parents were imbeciles, that's quote unquote imbeciles, people who the state of Virginia defined as feeble-minded, could be mandatorily sterilized. Now, I should emphasize the science behind this was highly faulty science. and Carrie Buck, the woman involved, probably had a normal IQ. But the question was, assuming that the science was right and that she did indeed have cognitive impairments that were genetic, did the Constitution prevent the state from interfering with her reproductive rights? And Justice Holmes, using the same principle, but this time writing for a majority, said no. Again, this is not a matter of the Constitution. This is a matter for the legislature. The only question is whether or not Mrs. Buck is given appropriate procedure, a hearing, a fair trial. Substance has nothing to do with the 14th Amendment. Needless to say, the country changed a great deal over the ensuing 4 decades. And by the mid-1960s, only 2 states had laws that prohibited birth control, and one of those was Connecticut. And Planned Parenthood and several reproductive rights groups established a test case. Their goal was to challenge Connecticut's law by distributing birth control or information about birth control and trying to get arrested. And that case was Griswold versus Connecticut. But I should emphasize the long-term goal of this case was to lay the groundwork for striking down abortion laws. And when the case came before the Supreme Court, the question was the same question under the 14th Amendment, whether or not there was a liberty right, a substantive due process liberty right to use birth control. And Justice Douglas, writing for the court, and you actually have this case available for you in the materials, said, specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. Do you have any idea what that means? Because I don't, and neither do other generations coming forward. It's legalese. He's trying to find some kind of basis to justify what comes next. Guarantees of zones of privacy. And he says that marriage is a unique area where there's privacy. I will add, by the way, Justice Douglas was married 4 times and divorced 3 times. The 4th time he was married to a graduate student he picked up at a lecture in his old age. But that being said, he viewed marriage as sacred and wrote, "We deal with the right of privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together for better or for worse, hopefully enduring, and intimate to a degree of being sacred. It is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects. Yet it is an association for as noble a purpose as any involved in our prior decisions." Now that all sounds well and good, but I want to emphasize the key point is, as wonderful as marriage may be, it is not intuitive or obvious that the liberty described in the Constitution includes marriage. Instead, Douglas, wanting to get the outcome that he desires, striking down birth control, anti-birth control laws, uses marriage as a basis for striking down laws to prohibit the use of birth control during marriage. And then, relying on that precedent, a few years later in Eisenstadt versus Baird, the court will extend that to unmarried couples as well. Dissenting justices Black and Stewart in the Griswold case are not opposed to contraception. They're actually very liberal in their personal views. However, they remember the era of Lochner. They remember the era when the courts would strike down laws that protected bakers from working extra hours or for low salaries. And they're concerned that once the court becomes aggressive in its interpretation of liberty in one area, in which they happen to like, it will become aggressive in other areas of defining liberty in ways they don't like. And therefore, they argue for restraint. And their argument in Griswold is that just because the law is what Stewart calls an uncommonly silly law, it does not mean that it's unconstitutional. Rather, if people don't like it, they should go to their legislature and get legislatures to repeal the law. The question is not whether it's good policy, but whether it violates the Constitution, and they feel it does not. It forms the backdrop for the Supreme Court's decision in Roe versus Wade. Even though the personnel in the court, the justices, have changed somewhat, the principles they're debating are the same. Writing for the majority, Justice Blackmun says that there's a right to privacy, and whether it's founded in the 14th Amendment's concept of personal liberty and restrictions of state action as he feels it is, and as we've talked about before, or other areas of the Constitution, some justices argued for it to be found in the 9th Amendment, it's broad enough in his view to encompass a woman's decision whether or not to terminate her pregnancy. In contrast, Justice White says this is the kind of area where reasonable people can agree to disagree. It's not an area where there's an obvious right or wrong answer, And it's not an area that the Constitution directly addresses, so it's exactly the kinds of questions that should be left up to democracy and to the states, for each individual legislature to make its own rules. Decide on your own whether the Supreme Court was right or wrong in the case of Roe versus Wade. But one thing about Roe is very clear. The individuals who believed, including Justice Blackmun, who I once discussed this case with, the individuals who believed that it would resolve the question and that abortion would no longer be a matter of debate in our society were clearly mistaken. And in fact, there's an argument to be made that it invigorated those who were opposed to abortion to try to push back against the courts and actually pack the courts with justices and judges who were opposed to abortion. That is exactly what the Reagan administration did when it appointed Supreme Court justices over the next decade during the 1980s. One of the goals of its Justice Department was to appoint justices who were likely to overturn Roe versus Wade. And in fact, Justice Ginsburg, Ruth Bader Ginsburg, had later said that she wondered whether Roe versus Wade wasn't premature because the political process might have actually worked itself out to legalize abortion through the legislature rather than through the courts, rather than producing that backlash. We will never know. What we do know is that Reagan and George H.W. Bush appointed justices whose stated purpose implicitly was to overturn Roe, and the most famous of them were Justice O'Connor, Justice Souter, and Justice Kennedy. And in 1992, they had their opportunity in a case called Planned Parenthood versus Casey. And the country expected, since the court was a much more conservative court, that they were going to overturn Roe and strike down the federal guarantee of abortion rights. And they did not do so. In fact, Planned Parenthood versus Casey made an interesting argument. The three justices, O'Connor, Souter, and Kennedy, wrote together in what is known as the plurality. And they said that they necessarily wouldn't have ruled the way the court did in Roe originally, but since it had been established as precedent, they did not feel it was appropriate to overrule the precedent. Liberty finds no refuge in a jurisprudence of doubt, is their famous description. Women had based their lives on the decision, and they felt bound by it. It raises the complex question of when a precedent can be overturned and how long and deep a precedent has to exist before it becomes unacceptable to overturn it. I will add, by the way, that the principle established in Planned Parenthood versus Casey was slightly different from that in Roe. Roe had established a trimester framework, and in the first trimester of pregnancy, the courts could not regulate abortion at all. In the second trimester of pregnancy, they could only regulate it to protect the life or health of the mother, and in the third trimester, only to regulate, was the only time they could regulate it to protect perceived fetal life. In contrast, Planned Parenthood versus Casey raised the issue of viability and established that the courts might have an interest in protecting fetuses once they were viable. It also noted that women should not be forced to suffer an undue burden when trying to achieve an abortion prior to viability. And it defined different areas that might or might not constitute an undue burden. And most of the areas that the court looked at, it did not find to be an undue burden, like a 24-hour waiting period or parental consent for minors. But it did establish an outer limit. It argued that spousal notification or partner notification or consent were an undue burden for women, and therefore made it clear that some things were unacceptable as restrictions to abortion rights under the Constitution. Decades that follow, a number of states have passed laws trying to convince the courts to overturn Roe versus Wade or circumvent it. We're going to talk about the case that ultimately overturns it in a moment, but I want to talk about one effort to circumvent it that arose before the Dobbs decision last year. Texas passed a law called State Bill 8 that is currently in effect, although still being reviewed by the courts, that imposed a civil but not a criminal penalty for abortion. It basically created a principle that private parties could sue individuals who engaged in abortion or facilitated abortions for others. This made it very hard to have standing to challenge the law. And we're going to talk more about this and read more about this during the course of the next week. But I want you to at least be aware of this effort, because it is not the effort that ultimately undid Roe. The ultimate effort to undo Roe that succeeded was a Mississippi law passed in 2018 and been put on hold by the courts that restricted abortion to only before 15 weeks of pregnancy. Now, as you may recall, under Roe, abortion was protected through the second trimester, or 24 weeks, and under Casey through at least viability. But this pushes back that date much earlier. And the court had an opportunity simply to uphold the Mississippi law and restrict abortion without eliminating the rights of Roe and Casey, and just simply limit them, which is what Chief Justice Roberts wanted to do. But the majority, written by Justice Alito, decided that the Roe decision and the Casey decision concomitantly were wrong from the start. And it said that the only kinds of substantive rights to be protected by the Constitution were those that were fundamental to ordered liberty, deep in the nation's history, and abortion simply wasn't one of them. And that was the majority opinion. There are two other concurring opinions worth thinking about that we're going to look at more closely during this week. Justice Thomas, a more conservative justice, felt the court should go even further than that. And it should not simply strike down the right to abortion, but it should look at other cases also based on substantive due process, like the court cases striking down anti-gay sodomy laws or the gay marriage cases. That's one extreme of the majority. And at the other hand, there was Justice Brett Kavanaugh, who said abortion is basically unique. The Constitution is neither pro-choice nor pro-life. He echoed Justice White from Roe's dissent, in which he suggested this was the kind of issue where people could disagree or agree, and it was for the political process. But he made a point of saying that that was the outer limit of what he was willing to strike down, that he was not making a commentary or inviting a challenge to other aspects of substantive due process. And then finally, there were the dissenting justices, Breyer, Kagan, and Sotomayor, who emphasized the importance of holding Roe and Casey as precedents and argued they should not be disturbed. And that is where the law stands today. We're going to have multiple sessions this week and next week where we can talk about these cases at great length after you've had a chance to read them. Do not be afraid of the complex legal language. Just try to walk away with a general sense of what the case is decided and what the views of each of the opinions assigned were. And I've tried to outline them on the cheat sheet, the synopsis for the week, so you can get a sense, even if you don't understand all the details and legal nuance of the opinions. Thank you.